In India, not every marriage performed with rituals, social approval, or even registration is automatically valid in the eyes of law. A marriage may appear perfectly valid socially, but legally, it may still be treated as void, illegal, voidable, or otherwise legally invalid depending upon applicable law. So today, we will understand: what is a void marriage? Which marriages are treated legally invalid under Indian law? What is the difference between void and voidable marriage? What happens to children born from such marriages? Can maintenance be claimed? And what important legal principles have courts clarified over the years? This discussion is meant purely for legal awareness and educational purposes and should not be treated as individual legal advice. Friends, welcome to my YouTube channel Legal Information Law Insights. I am Advocate Mukund Mahajan. I am happy to share that our channel has crossed 1 lakh subscribers and received the YouTube Silver Creator Award. Thank you for your continued support. Please freely subscribe to the channel for more legal awareness content. You may also support the channel through membership contributions of 59 rupees or 119 rupees using the GPay QR code shown on your screen. Thank you for your continued trust and support. Now, let us move towards today's topic and understand the legal concept of void marriages in India from statutory, judicial, personal law, and practical perspectives. What is a void marriage? Under Indian matrimonial law, a void marriage means a marriage that is generally treated as legally invalid from its very inception. In simple words, the law treats such marriage as lacking legal validity from its inception, subject to formal declaration by a competent court where necessary. However, in practical life, parties often approach the court for a formal declaration of nullity in order to avoid future disputes relating to property, maintenance, inheritance, custody, or remarriage. Under Section 11 of the Hindu Marriage Act, 1955, certain marriages are specifically treated as void. Similar prohibitions also exist under the Special Marriage Act, 1954. First category: second marriage during lifetime of spouse. One of the most common examples of a void marriage is bigamy. Under Hindu law, if a person marries again while his or her legally wedded spouse is still alive, the second marriage may be treated as void under applicable personal law. Section 5 of the Hindu Marriage Act, 1955 requires that neither party should have a living spouse at the time of marriage. Therefore, if divorce has not taken place, or the earlier marriage has not legally ended, the subsequent marriage may become void. Additionally, such conduct may amount to the offence of bigamy or related matrimonial offences under the Bharatiya Nyaya Sanhita, 2023. However, there is an important legal clarification. A mere relationship, companionship, or live-in arrangement does not automatically prove a legally valid second marriage. Courts generally require proof of essential marriage ceremonies wherever personal law mandates such ceremonies. Mere photographs, cohabitation, social recognition, or exchange of garlands may not by themselves conclusively establish a legally valid marriage where mandatory ceremonies are required by personal law. This principle has repeatedly been discussed in various judgments of the Supreme Court of India. Second category: marriage within prohibited relationship. Certain Indian matrimonial laws prohibit marriage within certain close blood relationships. Examples generally include brother and sister, uncle and niece, aunt and nephew, and similar close relations. Such marriages are generally void unless a valid and established custom permits them. Indian matrimonial law recognizes that some communities may have long-standing customs allowing marriages otherwise prohibited under general Hindu law. Therefore, courts may examine existence of custom, continuity of practice, certainty, and community acceptance. Without a legally recognized custom, such marriages may be declared void. Third category: Sapinda marriages. Another important concept under Hindu law is the Sapinda Relationship. Hindu law restricts marriage within certain close ancestral relationships on both the father's side and the mother's side. Unless a recognized custom permits such marriage, it may become void under the Hindu Marriage Act, 1955. The object of this provision is to prohibit marriages within closely connected familial lineage. Difference between void and voidable marriage. Now, many people confuse void marriages with voidable marriages. But legally, there is a major distinction. A void marriage is invalid from the very beginning. A voidable marriage, however, remains legally valid unless and until a competent court annuls it. Under Section 12 of the Hindu Marriage Act, 1955, marriages may become voidable in situations involving fraud, coercion, concealment of certain material facts in circumstances recognized by law, impotency, or certain forms of mental incapacity. For example, if consent was obtained through force or fraud, the marriage does not automatically become void. The affected party must approach the court seeking annulment, and statutory limitation periods may also apply depending upon the ground invoked. Until annulled by the court, such marriage continues to remain legally valid. This distinction is extremely important in matrimonial litigation. What about child marriage? Now let us discuss child marriage. Under the Prohibition of Child Marriage Act, 2006, the presently prescribed minimum age under the statute is generally 21 years for males and 18 years for females. However, an important legal point is often misunderstood. Not every child marriage is automatically void from inception. Under the statute, many child marriages are treated as voidable at the option of the contracting party who was a child at the time of marriage. However, certain aggravated child marriages involving trafficking, coercion, enticement, kidnapping, or exploitation may be treated as void under the law. Therefore, the legal consequences depend upon the facts and statutory provisions applicable to the case. Rights of children from void marriages. Now comes one of the most important and sensitive legal questions. What happens to children born from void or voidable marriages? The law protects innocent children. Section 16 of the Hindu Marriage Act, 1955 grants legitimacy to children born from void and voidable marriages. This means the child is not treated as illegitimate merely because the marriage of the parents suffered from legal defects. However, judicial decisions have evolved over time regarding the precise extent of rights, particularly in ancestral or co-parcenary property, depending upon statutory interpretation and factual context. Therefore, inheritance disputes in such matters can still become legally complex. Can maintenance be claimed in a void marriage? This area has evolved considerably through judicial interpretation. In certain cases, courts have granted relief where a woman was deceived, unaware of the subsisting earlier marriage, or entered the relationship bona fide and in good faith. Courts have, in certain situations, adopted beneficial and socially purposive interpretations to prevent exploitation and injustice. However, different statutes may apply differently, and entitlement often depends upon the specific legal provision invoked before the court. Entitlement to maintenance also depends upon the applicable statute, facts of the case, evidence, and the nature of the relationship proved before the court. Therefore, every void marriage does not automatically create maintenance rights. Does registration make an illegal marriage valid? This is another major misconception. Many people believe that registration automatically makes every marriage legally valid. That is incorrect. Registration primarily records or evidences a marriage. It does not by itself validate a marriage prohibited by substantive law. For example, if a second marriage is void because the first spouse is still legally alive and the earlier marriage subsists, mere registration cannot cure that illegality. Similarly, a prohibited relationship marriage does not automatically become valid merely because it has been registered. The substantive legal requirements of marriage must still be satisfied. Position under Muslim law. Under traditional Muslim personal law, marriages are generally classified as Sahih, legally valid marriage; Batil, completely void or invalid marriage; or Fasid, irregular or legally defective marriage. Marriage within certain prohibited blood relationships is generally treated as void under Muslim personal law. Traditional Muslim personal law has historically recognized limited polygamy for Muslim men, subject to applicable statutory provisions, judicial interpretation, and other legal consequences that may arise in specific circumstances. Therefore, the legal position may differ depending upon the school of Muslim law applicable, statutory provisions, and the facts of each case. Live-in relationships are different. A live-in relationship is not automatically equivalent to a legally valid marriage. The legal consequences of a live-in relationship depend heavily upon duration, nature of cohabitation, evidence, and applicable statutory provisions. However, Indian courts have recognized certain legal protections in long-term live-in relationships in appropriate cases, particularly concerning domestic violence protection, maintenance-related claims in specific circumstances, and welfare of children. However, every live-in relationship does not automatically create legal marital status or confer all rights arising from a legally valid marriage. Important practical reality. Many matrimonial disputes arise because parties rely only upon social ceremonies, photographs, community recognition, or registration certificates, without examining the actual legal validity of the marriage. Marriage law in India involves personal law, statutory conditions, evidence, judicial precedents, and procedural requirements. Therefore, legality depends upon much more than social acceptance. Conclusion. So friends, today we understood that under Indian law, some marriages are treated as completely void under applicable law. Some are merely voidable, and some relationships may appear socially accepted but still suffer from legal defects. The consequences can affect inheritance, maintenance, custody, remarriage, and even criminal liability. Therefore, understanding the legal status of marriage is extremely important before entering matrimonial litigation or initiating legal proceedings. Thanks for watching this video. If you found it informative, please like, freely subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.